Assalamualaikum. We are from the Guardian of the Constitution. We are presenting the question 3. So moving on to the first issue. The first issue is whether the Speaker of Dewan Rakyat has the constitutional authority under the Article 49A of the Federal Constitution to declare the seats of Tan Sri Baru and Datuk Sri Buruk vacant on the basis that they have changed their political party. So we are referring to the Article 49A1 that stipulates that a member of parliament shall cease to hold their seat if they resign from or cease to be a member of their political party or if they have been expelled. This is regarding the Constitutional Amendment Act 2022. And also, Article 49A2 carve out key exception to the operation of this rule. It states that a member shall not be considered to have ceased to be a member of a political party if they are expelled from the party. And the jurisdiction to give the speaker power to declare there is a vacancy or not, it is stipulated under Article 49A3, which is that speaker must satisfy that there is a vacancy before notifying the election commission, thereby imposing a constitutional duty to exercise due diligence and fair consideration of the case. So we can see the landmark case, which is the case of Nordin Bessaleh and another, and Dewan Undangan Negeri Kelantan. During that time, there was no anti-hopping laws that was enacted by Parliament. There is only anti-hopping law that is enacted by the Dewan Undangan Negeri Kelantan, which is the state of Kelantan. And then the court held that anti-hopping law that was made by the Dewan Undangan Negeri Kelantan was unconstitutional because it violates the rights to form association under Article 10. However, the court said that only Parliament has the power to make such law on that matter. So, we can see in the case of Afif Bardin and also case of Zulkifli and also a few cases that has said that a person cannot be expelled. In the case of Afif Bardin and Dewan Undangan Negeri Pulau Pinang, the federal court said that the court stated that Article 49A does not operate automatically. Instead, the mechanism is dependent on the political party to submit a written notice to the speaker. So, after a person being expelled, being ceased to be a member of the party or resign from his political party, the political party must send the notice to the speaker to inform that the seat shall be declared to be vacant. So, by applying to this case, Tan Sri Baru and also Datuk Sri Buruk were elected as a member of political party, and also they had be elected, and also they will be expelled by their political party, which is unfair, and also the speaker to declare their seats is. So Tan Sri Baru and Datuk Sri Buruk has been expelled by their party, has been removed the position from their party. It is not voluntary, it is involuntary. So they are not voluntary to be resigned from their political party. They have been expelled, they have been removed by their political party after they have won the election. So in Constitution, they stated that after a member of parliament win election by the ticket of bringing their party, so if they resign after that, the seat shall be vacant. But if they are being expelled, the seat shall not be vacant because it is involuntary. Hence, in conclusion, the speakers has no any rights to declare the seats of Datuk Sri Buruk and Tan Sri Baru vacant. So, the Speaker of Dewan Rakyat has no constitutional authority under Article 49A to declare their seats to be vacant on the basis that they have changed their political party. So moving on to the second issue, which is whether the expulsion of Tan Sri Baru and Datuk Sri Buruk from their respective parties amounts to a change of party within the Article 49A. Just now, we discussed regarding the whether the Speaker has constitutional authority to declare the seats vacant or not. But in this issue, we are discussing regarding whether their expulsion amounts to a change of party. So, we are referring to the section 160 of the Federal Constitution that includes the new definition of the political party. So, it means any society which by any office, object or rules regardless whether such object or rule is it principal or constitute merit and object of rule which is ancillary to its principal object. So, basically, political party is defined in the Constitution as the a person who are being a candidate in the political party, and also they have elections, and also they become the member of House of Representative or State Legislative Assembly. So we can see political party is like organization that has an organization that people can be a candidate, and also people can represent their parties in the parliament or state of legislative assembly. So we can see in Article 49A, which stated that the seat shall be vacant if the MPs who have won their seats by the ticket of being in that political party, so they have been resigned or been ceased to be a member, they shall their seats shall be declared vacant. However, in Article 49A, Clause 1A, state that a member of parliament, this provision also mentioned that the specific scenario when an MP will not cease from becoming a member of parliament when if his political party is dissolved or the party's registration is cancelled, or if he resign as his political party member when appointed as a speaker, or if his political party expel him as a member. So this new anti-hopping law was finally elected in the Constitution Amendment Number 3 Act 2023 in 2023. It is commonly called as anti-hopping law, Akta Anti-Lompat Party, and also it is to amend the Federal Constitution, aiming to discourage elected lawmakers from switching between political parties after they are elected by the voters, because it is unfair. The bill for the anti-hopping law was passed at the Dewan Rakyat on 28 July and also Dewan Negara on 9 August, and also before receiving royal assent on 31st August and gazetted as a law on 6 September 2022. So the plain and unambiguous language of this provision clearly distinguish between voluntarily cessation of party membership such as resignation or defection, and also involuntary cessation such as the expulsion from the political party. So Parliament deliberately included this exemption to preserve the constitutional right of MP and to prevent abuse by the political party, which may use expulsion as a tool to silence dissenting voices and indirectly cause a seat vacancy. For example, if one political party does not like their MP, does not in favor of the one MP, so they basically remove the MP from the political party. And if there is no provision that stated like this, the MP's seat shall be vacant immediately. So it is really unfair and will lead to the abuse of power. So hence why the provision provides the exemption, which is when the MPs being expelled from the political party, it does not mean to change of party, or it does not mean that they have been resigned by they voluntarily resigned from the party. So in conclusion, the expulsion of Tan Sri Baru and Datuk Sri Buruk from their respective political party does not amount to change of party under Article 49A 1A of the Federal Constitution, because this provision clearly exempts that exempts MP from disqualification in cases of expulsion. So the declaration of vacancy by the Speaker is not legally justified and may amount to an unlawful encroachment on the democratic rights of elected representatives and their constituent. So this is why it is important for us to have this anti-hopping law in our Malaysian constitution. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Amshar Naimani with metro number of 2225130. So I am going to continue with our third issue, which regarding of violation of free speech. So the issue here is whether the removal of Tan Sri Baru from his ministerial position and party membership for criticizing the Prime Minister violates his right to freedom of speech under Article 10 Clause 1A. So in this article, it mentions that every Malaysian citizen is entitled to freedom of speech and expression under the said Act. This article also have been acknowledged in the case of Dow Jones Publishing Co., where it mentions that it includes a broad variety of such as recognizing company and corporation as citizens, expressive activities, and also other non-verbal communications. So this case also laid down that the protection under Article 10 Clause 1 of the Federal Constitution only can include the citizen, whereby the non-citizen will not get the same protection under the same article. Article 19 of the UDHR, or Universal Declaration of Human Rights, mentioned that everyone has the right to freedom of opinion and expression, which further supports this idea of criticism of public officials, especially those in high positions like Prime Minister. However, the Parliament may restrict this right under the Article of 10 Clause 2A. According to the case of Muhammad Hilman bin Idham and others versus Kerajaan Malaysia, the majority of the Court of Appeal held that restrictions imposed by way of Section 15(5)(a) of University and University College, where it barred the students from participating in politics, were unreasonable. It is because there was no nexus between the exercise of their rights, of the university's right, and also the university students' right to express support or opposition against political party with public order and public morality. Where we can apply these guidelines or these principles to our current situation now, Tan Sri Baru's comments or criticism is actually just a mere comments, which cannot be which does not or doing nothing to combat corruption within the party. Where an obvious example of political speech, since it deals with questions of integrity, openness, and governance, all of which are of great public interest, this mode of speech is fundamental to democratic freedom. Furthermore, Article 43, Clause 5 of the Federal Constitution gives the Prime Minister and the authority to suggest that ministers can be removed from the cabinet, although this authority cannot be used to stifle criticism within the party or government. Additionally, Tan Sri Baru may be subject to procedural injustice and a punitive response to free speech if he is expelled from his current ministerial position. Without being given a chance to explain himself, the political parties which may control internal discipline, but they are nevertheless must be subjected to natural justice standards. If said so, in conclusion, Tan Sri Baru expulsion from the party, which was brought on by his criticism of the Prime Minister's integrityness, presents significant constitutional questions, even though his dismissal from the cabinet may be lawful under Article 43, Clause 5. However, according to Article 10, Clause 1A, where his remarks were kind of protected political expressions and punishing him for speaking out against corruptions run counter to democratic responsibility, which consequently, it may argue that indeed the expulsion from the party membership in particular violates the Federal Constitution under the Article of 10(1).
What issue is that whether the expulsion of Tan Sri Baru from his political party without being given a chance to be heard amounts to procedural unfairness. Article 8 Clause 1 of the FC guarantees that all persons are equal before the law. While this typically applies to the action of the states, it sets an important standard of fairness. In the case of Marachin, the court explained there are two types of fairness, which is administrative justice and from the Constitution, which is Article 5 Clause 1 and 8 Clause 1. However, Article 8 Clause 1 does not already apply to the private bodies such as political parties. Even so, Malaysian court have recognized the principle natural justice, which is right to be heard. and this is not limited to the government bodies. This can be seen in the case of Din Kelantan and Nordin Saleh, where the court held that private groups such as political parties must also follow the fair procedures, especially when their team members when the decisions affected the team members. The court stressed that the members must be given a right to be heard before expulsion. In this case, Tan Sri Baru claims that he was expelled from the political party without given a chance to be heard or explain himself or defend himself. So this raised the concern of procedural unfairness, even though Article 8 Clause 1 does not directly apply, but the decision may still be challenged through the judicial review or the party constitutions. Therefore, Tan Sri Baru may not succeed under Article 8 Clause 1. However, the lack of fair hearing of the expulsion could be the legally ground for the challenge of dismissal.
Moving on to the issue number 5, where it relates to the freedom of association, where the issue is whether the expulsion of Datuk Sri Borok from his political party and his subsequent formation of a new party are protected under the right of freedom of association under Article 10(1)(c) of Federal Constitution. So here, we apply the law of Article 10(1)(c) to the present case, where the expulsion of Datuk Sri Borok from his political party and his subsequent action of forming a new political party within the ambit of freedom of association guaranteed by Article 10(1)(c). This creation of new political party is an obvious expression that the right of association can be guaranteed to all citizens. Although this article is not absolute and still subject to restrictions under Article 10(2)(c), such restrictions must be justified in the interest of security, public order, and also morality. There is no indication in this case that the formation of the new party poses any threat to this interest, nor has any specific law has been cited to restrict this particular act. Furthermore, we can refer to the case of Malaysian Bar and Government of Malaysia, where it reinforced that while the right to form associations is constitutionally protected, it may be reasonably regulated by the law. The fact that this case provides an amendment to the LPA 1976 or Legal Profession Act, which restricts lawyers of less than 7 years standing being members of the bar committee or bar council. In this case, the court held that the right to freedom of association was the right to form an association but not to manage it. Thus, the LPA or Legal Profession Act 1976 was held to be not violating any regulations under the Article 10(1)(c). However, in this recent situation, it does not appear to contravene any lawful restriction as well. If a member of parliament resigns or leaves the political party which they were elected under, unless they were expelled to, they will no longer be a member of the Dewan Rakyat, according to Article 49A of Federal Constitution. However, this Article 49A, which established the anti-hopping clause, can be related to our recent situation where Datuk Sri Borok was expelled in this instance, which is specifically an exemption under 49A(1)(a)(2), where even though his party is specifically an exemption, his parliamentary seat is still in place. Additionally, under Section 7 of the Age Schedule, members of parliament are required to uphold the constitution, the exclusions listed under Article 49A. As a result, his dismissal and the creation of a new party are both constitutionally protected and legally acceptable under the freedom of association.
The sixth issue is that whether the refusal of Speaker to declare Datuk Baba's seat vacant despite his pledge of support to the Prime Minister amount to unequal treatment or discrimination in breach of Article 8 Clause 1. In Article 8 Clause 1 provide all persons are equal before the law. The law must be applied to all, but not all differential treatment is unlawful. In the case of Malaysian Bar, it provides two conditions for residual qualifications, which is intelligible differential and rational connection to the legislative purpose. In that case, the intelligent differential which is the distinction between lawyers with less 7 years of experience and those who are with 7 years and above. The rational connection between legitimate objective is that to ensure the leadership of bar councils is held by the experienced, independent and competent practitioners. Applying to this case, the intelligible differential is that Datuk Sri Baru and Datuk Sri Borok is elected under party ticket, which means they are under political party. However, Datuk Baba is elected as independent MPs. The rational connection to the legitimate objective is that Article 49, the Anti-Hopping Act, prevents MPs who are elected under a party from switching side to protect the party integrity and to avoid from betraying voters' trust. Since Datuk Baba was elected as an independent, the rule does not apply to him, and the Speaker's different treatment is reasonable and justified. Thus, is not valid under Article 8, Clause 1. The last issue is that whether the Speaker refusal to declare Datuk Baba's seat vacant can be challenged through judicial review. First, you have to know whether the Speaker's decision is justiciable. Justiciable means it can be reviewed by the court. It can be judicially reviewed by the court. If it's within the constitutional authority, meaning that it's non-justiciable, so it cannot be reviewed. If otherwise, it can be reviewed and it calls as justiciable. Next, under Article 49A, Clause 3, it gives power to the Speaker on the vacant to determine the vacancy seats of the MPs relating to 49A Clause 1, which is Anti-Hopping Act. Article 63 Clause 1 given the Speaker the parliamentary privilege from judicial reviewing his decision in the Parliament. In the case of Teng Chang Kim, the Selangor Speaker declared a seat vacant after the Assemblyman was absent for 6 months without permission under Article 69 of the Selangor Constitution. The court held that the decision made by the Speaker is non-justiciable and protected by the Parliamentary Privilege Article 72 Clause 1 for the state, as it was met within the Speaker's power. So this is also reaffirmed by the case of Ronald Kiandi. But it can be distinguished under the case of Zamri Sivakumar, where the Speaker's decision of suspension members was ultra vires as it was not provided under Perak Constitution or standing orders. So the decision was justiciable and can be reviewed. So applying to this case, Datuk Baba case, the Speaker ruled that the Datuk Baba pledging support to the Prime Minister is not equal to the party switchings or sweeping or hopping to another party under 49A. So the decision made by the Speakers is non-justiciable and likely to be overturned or just judicial review by the court.